to advance social justice causes has led me to take actions.
Hi, everyone. My name is Avi. I'm a grad student working with Justices Global, and I'd like to welcome you all. Thank you all for taking the time to come to our event tonight. It's titled Patents, Power, and Global Crisis. Will your research be shared with the world? This event is hosted by Justices Global, which is an organization that works towards creating a more equitable and sustainable society. And we will be hearing from speakers that focus on the impacts of IP access to climate technologies and life-saving medication. So I will pass the reins to our next speaker, Jeremy Koenig.
Thank you, Abby. Yeah, so my name is Jeremy. I'm a computer science researcher at Yale University, and I'm a member with Abby and Rashmi and Owen and others of the group within Justices Global that's organizing today's event. And I'm gonna get us started with some framing remarks. So a few words about Justices Global first. It's an organization that seeks to promote progressive internationalism, and what that means is that a lot of the crises we are living through has become more and more apparent this past decades that neoliberal globalization is driving this. And so this idea of a global market coordinated only by sort of competition between people and countries. And so that creates dynamics of race to the bottom dynamics in terms of people's working conditions. That creates a situation where it's impossible to address climate change, to have proper global public health. So those are some topics we're going to talk about today. And so Justices Global wants to make the case that going back to the sort of nationalistic protectionism and isolation as we've seen sort of take root in politics over the past years is not good enough, but instead we need to create a version of globalization that's rooted in international cooperation and people and countries sort of working together across borders to create things like an international industrial policy and so on and so forth. And so our group is starting from the principle that if this is going to happen, unions have a key role to play in creating this new globalization, because it's like one of the few powerful constituencies that can be in favor of progressive politics on a global scale. And the case we want to make is that not only unions would play an important role in sort of creating this different world, but also they have a lot to gain from adopting progressive internationalism as a way to look at the world and as an analysis. And we think it's especially true in academia, where people from all kinds of different countries work together for solving global problems like the ones we're gonna talk about today, right? And so I want to make a case, like use my own example as an illustration of that. I came to the US from France in 2012 to do a PhD in computer science at Yale University. And soon after, I joined the union organizing campaign that was already going on at the time. But I was in a situation where most of the folks in the union were American students from humanities departments that didn't have a very good understanding of like where I was sitting as a French person in a STEM department, trying to organize a majority of international students, many of them from China, from India. And so my first exposure to progressive internationalism was at that time trying to understand what my colleagues were going through. And that became a very useful tool for me in my organizing, especially, for example, when the US-China relationship took a turn for the worst, and my Chinese colleagues sort of got caught in the crossfire of like Trump's trade wars and COVID travel restrictions, all kinds of visa issues that persist to this day. And so I couldn't have been an effective organizer if I didn't understand the forces that shape this, the things that my colleagues were experiencing day to day. And if I didn't have an analysis of like what was behind that and how we could hope to change it someday. So I leave it there. Back to you, Abby, but I hope you'll enjoy our event today and that we can think through together what are the connections between these big global issues and our work as organizers and how we can connect those things together, because I think it's very important. And the topic of intellectual property and the global IP regime is a very key point where these things meet. So I'm excited for today's event, and back to you, Abby.
Great. Thank you for that introduction, Jeremy. So next I'd like to introduce Professor Brooke Baker. He is a professor of law at Northeastern University and senior policy analyst at the Health Global Access Project, also known as Health Gap, with one of his focuses on patent barriers to affordable medicines. He has been an HIV/AIDS activist for 25 years and has worked on ways to increase affordable access to HIV medications in communities that need it most. So I'd like to welcome Professor Brooke Baker, who will now be speaking. So thanks.
Thank you very much, and I'd ask Ben to start sharing the PowerPoint that I've prepared. Okay, so next slide, please. So, you know, I want to start with why I got involved in the work I currently do. And on the right-hand side of the slide are the pictures of at first, my 2.5-year-old son, who was diagnosed with rhabdomyosarcoma in 1986 and began a protracted course of chemotherapy, radiation therapy, and surgery, and who fortunately has survived because of his access to probably the best pediatric urology surgeon in the world and to Dana-Farber Institute. And, you know, even though he's certainly undergone multiple, over 20 surgeries in his lifetime with respect to his cancer and some of the consequences of that therapy, he's alive today. He just turned 40. That's a picture of him, a more recent picture of him at the bottom. And in addition to being a social worker now, he is very active in Make-A-Wish Foundation. And Chad was very lucky at the time he was diagnosed in one sense. One, there had been lots of medical advances. and we were fully medically insured and had, access to really the best treatment in the world. And he was also diagnosed shortly after there had been discovery of a test to detect HIV in the blood supply. And so he was not exposed to HIV for the many blood transfusions he met. I remember that my wife and I were in a cancer support group at Children's Hospital, and one of the fathers there had continued to come. His son had survived his cancer, but died of AIDS as a result of a transfusion he had gotten approximately a year and a half earlier. And of course, that stuck with me, the close call that our son Chad had the HIV exposure at a time when there really wasn't any accessible or available treatments. 10 years later, in 1997, at age 50, I had my first sabbatical in South Africa. I went to Durban, South Africa, and taught at what was then the University of Durban, Westville, now University of KwaZulu-Natal. Made strong friendships, stayed for 6 months. Chad came with us. And, the HIV/AIDS pandemic was really just starting to become widely discussed in South Africa at that time, not in very productive ways, but it was being discussed. A year later, when I went back, they had done anonymous testing of some of the students who pitched up at the clinic, and 27% of the female students were HIV positive. The infection rate for male students was approximately half of that. And the infection rate was much higher for the Black African students than it was for the Indian, South Asian diaspora students who were also attending that university. The infection rate among women was over 40% for Black African. And none of them had access to treatment. And that meant that essentially all of them would be dead within 8 years. And many more would be infected over the course of their young lifetime. I also worked while I was there in a law clinic and had exposure to client cases where the AIDS pandemic was becoming painfully clear in the human costs of that pandemic. One of the early cases that we worked on was a couple that came in because the hospital had mixed up their baby in the morgue because there were so many babies that they had given their baby to someone else and left that other baby for them to bury. And that was certainly against their culture and tradition. And it was just frankly because there were so many AIDS-related deaths of infants that the hospital was just overrun. So I put 2 and 2 together. The students there were just as important to me as students here in the US. The lives mattered to me. I realized what a close call my son had, what a difference access to medical care and medicines in particular had been to his recovery. And so I just had to do something about it. Next slide, please. So this is I think a very useful slide to talk about the impact of generic medicines and on access to medicine. So this is a slide that Medicine Software there put out that shows the change in the price of antiretroviral medicines with the introduction of generic competition. When I went to the International AIDS Conference in Durban in June of 2020, the cost of antiretroviral therapy in Durban was essentially the same as in Boston, $10,439. A little bit cheaper in Brazil because Brazil had not provided patent protections for pharmaceutical products that had been discovered before a certain date in the mid-90s. And so it was able to make some domestically. So its prices were, roughly 25% of what the global price was. And then in January of 2001, a company in India, Cipla, made a revolutionary offer to produce generic antiretroviral therapy of basically $1 a day. It said it could provide the medicines at that price. And once Cipla announced that price, the major pharmaceutical companies began to drop their prices, not as low as Cipla, but certainly lower. And as more and more companies entered the field and as economies of scale increased because of increased number of people on treatment, the cost of medicines continued to drop all the way down to you see a cost of what was then the first line treatment of $61 per person per year, as opposed to the then current price in the US at that same time for first line therapy, which was roughly $30,000 per person per year. Next slide, please. So this is my crude slide to show a certain kind of equivalence. And a very simple version of what made access to medicine work, particularly with respect to HIV/AIDS. As I said before, the price in South Africa was $10,479. The current best first-line therapy, which is dolutegravir based, in the U.S. costs $45,000. It's currently available in nearly 100 countries, low and middle income countries, and essentially all of sub-Saharan Africa for $45 per person per year. So that's a 1,000-fold decrease in the cost of annual supply of highly active antiretroviral therapy. When I was in Africa at the International AIDS Conference in 2000, in the entire continent, approximately 20,000 people were on treatment. That was out of what was estimated to be almost 20 million people infected with HIV at that time. 23 years later, today, there are over 20 million people on antiretroviral therapy in Africa, a 1,000-fold increase. So I don't think there's any happenstance in these very simple numbers that I'm presenting. With the global price of antiretroviral therapy falling because of increased access to generic medicine, where patent barriers were not in the way, you could get very low cost medicine, pennies a day, and you could thereby greatly increase your purchases of medicine and treat accordingly many, many more people for the same amount of money. So the simple version of the success of AIDS activism is that an international coalition of treatment activists worked on trying to overcome intellectual property barriers to the initially off-patent generic antiretroviral medicines, and then overcoming patent barriers on newer medicines through various mechanisms, including the medicine patent pool, compulsory licenses, and other measures. Next slide, please. So here's the lineup of issues I think that are relevant to the folks on this call. So who owns and controls knowledge? Do we have a knowledge common and global public goods? Or do we have a knowledge jungle and enclosure? What is the role of human rights? Do we have access to health and health tech products, the right to sustainability and climate control and green technology? Do we have a shared right to the benefits of scientific progress and its practical applications, or do we not? In terms of the innovation side of things, do we have open source research? Do we have open science in collaboration between researchers globally? Do we have transparency on research results? Or do we have secrecy, information, and research silos that then turn into commercial silos as well? And finally, with respect to access to the resulting medical products that are the fruit of scientific research and the basic research that many of you might be doing, do we have equitable and affordable access to quality assured products that address unmet global needs? and give people access to affordable, quality assured products. Where do we have exclusive rights, commercially motivated product development and selection, artificially restricted supplies, monopoly-based pricing, and inequitable and market-based distribution. In other words, rich people at the front of the line and poor people at the back are nowhere. These are the issues that are, I think, relevant to our discussion today, including our discussion of access to medicine. Next slide, please. So there are two legal regimes which help promote big pharma's IP and market hegemony. One is Bayh-Dole, which probably many of you are familiar with, which was a new national legislation in the U.S., which tried to promote theoretically promote the development of the scientific progress and the research developments at universities and other small research institutes, and to encourage that those innovations be patented, and then that they be licensed and subject to technology transfer to private entities. The theory being that too much was sitting on the shelves and that there wasn't commercialization, and that there had to be both an intellectual property right that the researcher held, and then a willing private entity that would do the additional translational research to bring the product to market. The second big piece of legal regime was on the international stage, the World Trade Organization agreement on trade-related aspects of intellectual property rights. Previously, there had been many countries that did not provide patent rights to pharmaceutical products. They were considered too important. Similarly, there were many regimes that did not, national regimes that did not patent agricultural products or food products. And Big Pharma led the way in putting together an international coalition of IP right holders who convinced U.S. first, then Europe and then Japan to negotiate on their behalf at the WTO, what became the WTO, to have a global minimum standard of intellectual property protections on patents, copyright, and several other intellectual property rights. In what concerns us most, there was a agreement that there would be a 20-year minimum term of patent protection, that there could be no discrimination, continuing the discrimination against a field of technology like pharmaceuticals. And similarly, there could be no discrimination against companies on the basis that they would be importing products, importing products to other countries instead of producing them domestically. And then on top of the TRIPS agreement, then the US, Europe, and other high-income country negotiators tried to impose a TRIPS plus agenda on developing countries in the form of data exclusivity, which would prevent the reliance on regulatory data submitted by originators to approve bioequivalent and generic products, patent term extensions and ways to evergreen patents, meaning getting patents on minor modifications of existing products, patent registration linkage, which I won't bother to describe, trade secret protection, which is not unlike some of the research secrecy that universities still maintain, and then a very vigorous enforcement agenda. And COVID-19 is a case study of what goes wrong when you have this legal regime in place. We had artificially restricted supplies where we didn't really use the manufacturing capacity of other people who manufactured globally. We had needlessly high prices. The industry reported $100 billion in profits alone on vaccines and therapeutics during 2 years of the pandemic. We had grossly inequitable distribution, resulting in what we call vaccine apartheid, and a blatant refusal by Moderna, Pfizer, and BioNTech to share the messenger RNA vaccine technology platforms that are so important in trying to overcome COVID, but also so promising in terms of other disease areas. Next slide, please. So this is a little visual to help us understand what's happening with university research. Publicly funded research, NIH in particular, but Department of Defense as well, funds university researchers like yourselves to do what is comparatively high risk but relatively low cost research and development on the disease targets and promising therapies with respect to the same. That the progress of that basic research is patented and let's say eaten by early university researchers, usually your principal investigators or tenured folks. That then gets eaten by a small spin-off company that takes the ball a little bit further and does a little bit more development. If they can intrigue a bigger shark, they get a venture capitalist capital venture that comes in and gives them some money for the patented and now more promising product. And then finally, once the product is further proven, it's eaten by a big biopharmaceutical company. And each of these are relatively costly acquisitions, and all of them are based on the promise of monopoly profits on the original invention that was the result of scientific research at the university. Next slide, please. So, historically, university researchers, did the research for fame and glory and the respect of their peers, and basically to share the fruits of their research with the global community, for the public good. And, motivated by intellectual curiosity, hard work, teamwork, collaborations, cross-fertilization between disciplines, peer recognition, and they had significant degrees of institutional and public support for those activities. Post-Bayh-Dole, we've had much greater growth of research silos, of patenting and secrecy of results, technology transfer, spin-off, venture capitalism, privatization that I just described. And in particular, in the medical, biomedical context, we have university ownership of early stage inventions, and then control over the terms and conditions of technology transfer and licensing to private entities, which results in distorted production product development priorities, privatized monopoly control, meaning can exclude competitors, emphasis on evergreen strategies and high price and thus profiteering, and market fundamentals in there, the rich countries in which consumers get products first and the poor get them never or late. Next slide, please. So the question is, what can people like yourselves inspire yourselves and others to do who are university researchers? What are new models? What are changes in the innovation access ecology that you can promote? So certainly there needs to be a different system for incentivizing and supporting collaboration, open science, transparency, and an information commons. Instead of thinking that my research has to be kept secret so I can get a publication, and then maybe I will also have the basis for a patent application that will then go to my university, we could have a different set of motivations, which would frankly result in better and more efficient and more cost-saving research and in general. We could have medical research that was oriented towards global needs and neglected populations instead of towards the blockbuster and niche buster medical products that are prioritized in rich country markets and by which the disease is affecting rich people. We could have the development and adaptation of medical products for use in resource-poor settings, so that we wouldn't necessarily have technologies that are all bells and whistles, but aren't really needed at the community and point of care level. We could guarantee that there are public returns on public investments, and we could encourage much greater public investment and support for the kind of research that all of you are engaged in. We could insist on public interest control over the terms and conditions of university technology transfer, that there would have to be licensing and technology transfer to alternative producers besides big biopharmaceutical industry, especially in low and middle income countries. There could be terms requiring fair pricing, even in rich countries. There could be terms on equitable distribution that meant that they would have to register and actually market the products in all underserved markets, not just in rich countries first and in poor countries maybe never. And then finally, if we really, thought, big, if we had even broader ambitions, we could think about trying to make medical products and medical research true public goods, and that we would treat the medical products like we would treat what Rachel's going to talk about next, which is climate control and green technology. We could treat them differently because they are indeed global public goods. Well, thank you very much.
Great. Thank you so much, Brooke, for that fascinating talk. We'll be doing a joint Q&A session at the end of both talks. And so now I would like to introduce Rachel Thrasher. Rachel is a researcher with the Boston University Global Development Policy Center, and she studies policy issues relating to trade, intellectual property, and their impacts on access to medicines in the climate crisis. She is the author of the book, Constraining Development, The Shrinking of Policy Space in the International Trade Regime. Thank you, Rachel, for speaking today with us.
Yeah, thank you, Abby. And I am going to attempt to share some slides with you. Hopefully, in a moment, you'll be able to see. Let's see if I can do this. There we go. You'll be able to see just the slide, and I'll be able to see my notes. Here we go. Does this look okay? Thumbs up? Okay, thanks, Abby. Great. So thank you to all of you for being here tonight. Thank you to Ben for inviting me, and to all the people at Justices Global for hosting this event. I think it's really important to talk to graduate students who are really at the front lines of creating a new technology, the front lines of finding out what new technology we need, and to talk to you in particular about the intersection here of labor rights and intellectual property, and as Brooke mentioned just a moment ago, my particular interest right now, which is how this intersects with climate technology. So let's just begin with where you all are, or where I think some of you are. As graduate students, in particular, if you're in the STEM field, you're all in a position to do important groundbreaking work in frontier technology fields. And some of you, I think in preliminary interviews, have mentioned a desire to understand more about how to retain control over your own ideas and inventions. And others have noted an interest in making your inventions more accessible globally. And as Brooke just really helpfully pointed out and explained to me in a way I didn't understand fully before, often your work ends up belonging to the university, and they're free to non-transparently transfer it to whomever they would like. And so retaining an interest in a sense of your own ownership can keep you invested in the end uses of your inventions and give you power to actually control some of those end uses. And so to the extent that you would like ownership or control over your intellectual contributions, what I'm hoping to do tonight is to point to a few sort of key aspects of this study area. So first of all, I will talk about the importance of climate technology development and diffusion in terms of our global climate crisis and the global climate commitments that governments have made. Second, we'll talk briefly about some of the theoretical underpinnings of how intellectual property protection is supposed to work to incentivize both innovation and promote diffusion of knowledge. And some of this may be too basic, but hang in there, because I have some new research or newer research that I will be showing you some of the conclusions from. That is to say, what is the existing evidence about the links between intellectual property rights like patents and global access to essential climate technologies. And finally, I'll end by talking about a few things you can do about it. All right. So almost no one is contesting the statement that climate change is an existential threat, and an effective response will, and this is a quotation from a researcher who I won't call out because I think they might be on the call right now. And I also want to note that I have a long list of resources that have been really helpful to me. I'm happy to share afterwards. But an effective response will critically depend on the cost, performance, and availability of technologies that mitigate and help countries adapt to our changing climate. And this will require a virtual revolution of technology. This is a giant structural, global economic structural change based on a change in technology. And what's so amazing is that much of this is happening, and it's happening so quickly. So 2 years ago, the International Energy Agency released a roadmap to net zero by 2050. And in that report, there was 50% of emissions reductions that were needed to reach net zero actually relied on technology that was only in the prototype or the demonstration phase. So it wasn't commercializable, it wasn't launchable or implementable yet. But as of the World Energy Outlook that was released just 2 weeks ago, that number was down to 35%. So that's in just 2 years. We've had an enormous explosion of technologies that have gone from prototype to commercialization. And that is to say implementation, deployment of essential technologies for meeting the climate crisis. So for those technologies that are now proven and able to be deployed, the challenge is to then scale up in a way that promotes resilient, inclusive, and affordable transitions across countries. There are still, of course, technologies that are not really there yet. And I think the intellectual property piece may have a different impact on the technologies at prototype phase rather than technologies that are ready for scaling. And we can talk a little bit more about that in the Q&A, and I'll mention it briefly in a bit. However, while the clean energy deployment scaling is happening very quickly in some countries already, in China and in most high-income countries, for emerging market and developing countries other than China, investment and scaling up will need to increase by 6-fold over the next 10 years. So we're talking about an enormous increase in access to climate technologies. And at least in some cases, that will mean empowering firms in those countries to contribute to the scaling process. So we're not just talking about ramping up production in the United States to export it everywhere else. We're talking about production worldwide in some of these essential technologies. So, so just as a sort of a point of reference, right now, this is according to the World Energy Outlook that I just was taking a look at today. The distribution of clean energy use across countries is much more unequal than the distribution of energy consumption in general. So what that shows is that the access for clean energy is more unequal than access to energy in general. And that's important for our message tonight about access to essential climate technologies. So governments are not unaware of the need for rapid and equitable technology transfer to developing countries. And it's been actually an aspect of the very first discussions in Rio in 1992. Here you can see an article from the Paris Agreement, Article 10.1, in which it states that parties share a long-term vision on the importance of fully realizing technology development and transfer in order to improve resilience to climate change and reduce greenhouse gas emissions. This aspect of technology transfer, which is another word for diffusion of these technologies, access to these technologies, has been a part of every environmental climate agreement since 1992. Countries have been invited to identify specific technologies that they need in order to meet their climate commitments. And so countries are able to put forward their statement about what it is they need access to in order to reduce emissions the way they need to, in order to adapt the way they need to the climate, to the changing climate. So this is basically how technology diffusion is supposed to work, right, in theory. And this is very, very basic, but bear with me. It was a helpful framing for me when I read this recently. So generally, this follows the pattern. This is the way that most countries pursue the dual aim of incentivizing innovation and making sure that innovation is diffused for the benefit of the general public. First, the innovator files for a patent for a new invention, and then thus making the information about the invention essentially public information. In exchange for that, the innovator receives a temporary monopoly right over the commercialization of the invention, which, as Brooke just mentioned, under the TRIPS agreement at the WTO is a requirement of 20 years. And once the monopoly period is ended, the innovation enters the public domain and may be used or imitated by others. It is, of course, much more complicated than that. And I won't repeat what Brooke said about some of the ways that that innovators have in the past used this particular process to expand and extend their protection past the 20-year period. But suffice to say, it has not gone as smoothly as this seems to say it does, in particular in the pharmaceutical field, and we have lots and lots of research to show that. So this is the basic theory behind it. So ultimately, the system is attempting to balance these two interests, those of incentivizing innovation and then promoting diffusion. So to the extent that any particular instantiation of the system offers more incentive to the one, it can slow down the other. And this was quoted in another resource I was looking at today. Nathan Rosenberg said in 1972, so many, many years ago, to the extent that a patent offers protection to a patent holder, it does so by slowing down the diffusion of inventions. So when we are tinkering with these levers of patent rights, the duration of them and the exclusivity of them, we are changing the balance between these two interests. And different countries are going to have different interests in that balance. They're just going to have a different view of what's the best balance for them. So this is where I get into the evidence, and I've been kind of neck deep in this literature, and I have found some really boring things and some really innovative and interesting things. So the question is, do patent rights lead to more innovation and sufficient diffusion, right? That's what it's supposed to do. Does it do its job? And sort of historical research on high-tech innovation in general. Again, I'm not including a lot of the access to medicines pharmaceutical research, in part because Brooke has covered that sufficiently. But in general, strong patents in importing countries, excuse me, that says rights, but that's a typo. Strong patents in importing countries correlate with high-tech exports. That is to say, you get more high-tech exports if into the importing country, if they have stronger patents. Generally speaking, and I emphasize that, strong patents correlate with high-tech foreign investment flows. So in addition to imports, there's more foreign investment in the high-tech fields. Generally speaking, strong patents correlate with more and more licensing, more and easier licensing of technology. Those are the three measures by which researchers try to decide whether or not there's been sufficient diffusion. The trick is that this is only true for high-income countries or very large middle-income countries. And so this is where the evidence starts to get, a little more interesting. So in addition to showing that the evidence of a positive relationship between intellectual property and access showing that is a positive relationship is limited to sort of high income countries or larger markets. Some sectors respond really differently to enforcement of IPRs than to others. So this really will depend on the specific characteristic of the sector, sometimes whether it's more science intensive or engineering intensive, whether it's more likely to be imitated by researchers, where they're more capable of imitating it, what stage of maturity the technology is in general, as well as other characteristics. And so to say IPRs are set up to promote innovation and diffusion, it's never quite that straightforward. Some of the most interesting recent research measures whether strong IPR enforcement leads to a transfer of patents to non-originator countries. So this is a different measure than trade or investment or licenses. It's measuring whether a patent is filed in a country that's not the country of the original innovator. And it's saying that because patents are correlated with the presence of trade, because patents are correlated with investment, then the presence of a patent could be a sign of access. There are huge problems with that approach. And if we want to get into the weeds on that, on those details, we can talk about in the Q&A. The reason the research are doing this is because you can map one-to-one the technology that's being innovated and the technology that's being, transferred, quote unquote, through the patent. So you have a one-to-one mapping there. But even in this most recent research, this is from 2023, I think the article I'm pulling this from comes out actually next month. Stronger IPR, intellectual property right enforcement, is actually not correlated with transferred patents from originator countries in the most recent research. And for low-income countries, that connection is even weaker. That is to say that stronger IPR enforcement is not even correlated with more patents from non-originator countries, which to me was a really surprising thing, given the problems with that type of measurement. Moreover, there is almost no evidence of any of the adaptation technology needed in the most vulnerable countries showing up in any form, whether through trade or investment or patent filings. So if we talk about climate mitigation technology is super important for developing, for vulnerable countries. Adaptation technology might be even more important. And what we're seeing is that most of the innovation is happening in the global north, and almost none of it very trace amounts of that technology in any form is getting to the most vulnerable countries. So that basically covers the research that we've been doing most recently. The question is then, now that you are armed with all these great studies and statistics, what can you do? And as graduate students, the first thing I'll say is to advocate for intellectual property provisions in your union contracts. Remember that unions, and you probably all know this more than I do, but unions regularly renegotiate their contracts. And so incorporating intellectual property into a contract isn't a one-time deal. You can use a small success to jump off and add more into the next contract. And in that way, slowly and progressively increase your ownership and control over your invention so that you can have more say, informed by some of the concepts we've been talking about tonight. Second, once you have that ownership and control, you can remember the things that we've talked about and maybe find out more. And hopefully there will be more research coming out about all these things over time. But just to remember about the need to strike the right balance of interests between encouraging innovation and diffusion. And when you have a chance, exercise your control in a way that prioritizes the scaling up of essential technologies in developing countries. And finally, spread the word. Your fellow STEM researchers in your universities may or may not have this kind of information, may or may not have heard about some of these concerns. And so in some cases, it may be that in some cases filing for patents on an innovation is the right way to go, depending on the stage of research that you're in, or perhaps it's your only option if it's required in order to comply with a grant reporting requirement. And patents can be a better alternative than using trade secrets to keep hold of proprietary information, because at least it places that information in the public domain more quickly and more transparently. However, as Brooke so beautifully pointed out, there are other options for incentivizing innovation, and participating in open knowledge systems and perhaps patent pools or other options for sharing innovation might be a better way to promote ongoing and innovation, much needed climate innovation over the next several decades. And I think that's it. Thank you so much.
Great. Thank you so much, Rachel. That was a fascinating talk. And I'd like to thank our speakers again, Rachel and Brooke, for taking the time to come here and talk about this really important issue with us. And I would like to move on to a joint Q&A session, and I believe Rashmi is going to be facilitating this.
Thanks, Abhi, and thank you so much, Dr. Becker and Dr. Professor Thresher. It was really fascinating and very informative, both of the talks. And yes, if there are any questions from the participants, please feel free to unmute yourself and ask your question.
I can get us started with a question. I'm curious about how, outside of how this affects researchers, like the case to the broader American public, like how does the lack of diffusion and low and this is maybe a softball question, but I wanna think about how this maybe affects the broader American public and what sorts of arguments we could make, thinking about how to negotiate strongly for the kinds of IP provisions you talk about that appeal to the broader public. How does like not getting access to, like, I know this was very clear in the COVID-19 crisis where the height of the pandemic, where lack of access to vaccines in the global south meant that variants were coming back here. But I wonder if you can talk more about that, or ways that we can maybe think about messages or narratives that might be useful in the organizing that we do.
Well, you're right that the COVID-19 was, an extreme example, in part because it was a global infectious disease that continued to mutate very quickly. And so the failure to vaccinate and to treat meant that people were more likely to become infected, more likely to pass infection to others, have longer periods during which variants could mutate and come back and haunt us. So, I mean, nationalism, what we called vaccine nationalism, was in a sense the worst possible response, not just for the excluded countries that had delayed or very limited access to vaccines, but it came back and kicked us in the rear end. I mean, all the new variants that developed and came back, of which there may be more in the future. COVID is not, it's not over by any stretch, and there are more pandemics in the future. So the idea that that pandemic-related products are global public goods is probably the clearest and easiest example. But I would argue that health in general is a public good, a global public good. A healthier world is better for everyone, not just with respect to the diffusion of disease, but global well-being probably reduces conflict and makes people more productive and makes people happier. And it's just all good, right? And it's very easy to see that. I mean, you can take it from your family and extend it to the world. When someone's sick in your family, things aren't going great for the family. And in a way, in the global family, when people are sick and dying and suffering excess mortality and morbidity, it's just not good for the whole human family. And I think that's a point that we can make. And it's a real problem in U.S. politics that there's so much domestic focus and so much focus on what's good for us. But I mean, I think having global perspectives on health is a really good lever. And I'm sure Rachel can say the same thing about climate control. It's exactly the same.
Yeah, I would say the global public good argument is the baseline, right? We're seeing, I mean, a characteristic of the global public good is that it will not be provided sufficiently if left only market conditions. And that's clearly what we've seen with respect to responses to climate change in general. That's why we have so much climate policy going on. That's why the US passed the IRA recently, because it was seeing that just leaving it to market condition, sort of to the market, was not going to produce the amount of innovation and production of essential climate technologies as would be needed to make the transition. So when we talk about, what we've been talking about tonight, of access to those technologies for the developing countries in the world, we have to remember that mitigation of climate of emissions and mitigating the climate crisis is going to require participation by every country in the world. And on analogy with COVID, where no one is safe until everyone is safe. In climate mitigation, it's the same story. If the U.S. cuts its emissions to zero, but we don't do anything to support the transition of developing countries, we are all going to get a warmer Earth, whether we like it or not. And so I think the idea that we need that we need to transfer that technology in some way, make it accessible, is a fairly obvious argument. But I think it might help. One more thing that might help is to realize that at a national level, access is inequitable as well. And I think this is probably true in the pharmaceutical case. So to the extent that there are higher prices on technologies that are needed even for low-income communities or more impoverished regions of the United States, we need to make sure those groups have access and don't feel further isolated by this energy transition. So that's another component I wanted to add. Thank you.
Thank you. We'll take the next question from Dan.
Hey, thank you. Really wonderful talk. Thank you so much for organizing this. On the issue of trade secret or industrial secret, unlike patents can eventually they're public, and they can eventually be released to the public. So there is some public good, and on this trade-off of incentivizing innovation versus public good, trade secret has just a horrible balance. It nearly doesn't reach the public good, right? So how could we envision a roadmap for eventually abolishing a trade secret in some form? If you could elaborate on that.
Well, I think people's attention to trade secrets really increased dramatically in COVID because the messenger RNA vaccine technology and vaccines in general require a great deal of specialized commercial manufacturing know-how that is treated as a trade secret. And then, of course, industry treated almost everything as a trade secret. There are purchase and sale agreements with developing countries, actually with Europe and many low and middle income countries. Their pricing policies across the board, their research results, they keep in secret. So trade secret law has really run amok. And the problem with it is at least threefold. One, it's self-defined by the entity that wants it. I mean, they can decide anything. And historically, they had wanted clinical trial results and data to be kept secret, but there were public health exceptions that were created. The second thing is that it just, as you say, it prevents the transfer and knowledge needed for alternative producers that need access to that information. And governments are complicit with it, unfortunately, and our government and some others have been enforcing greater protections for trade secrets to our collective detriment. Fortunately, the International TRIPS Agreement does not prevent countries from overriding trade secrets or creating exceptions to trade secrets. There are certainly proposals that there could be and should be compulsory licenses on trade secrets. There are strong arguments that there can be and must be mandatory disclosure requirements with respect to certain kind of information held by industry, just because the public interest and public health concerns are so manifest. And so I think in general, we have to, it's one of the reasons why I emphasize transparency and overcoming secrecy silos as much as I did in my presentation. The universities fall into this a little bit. Researchers are prone to the same kind of secrecy as opposed to openness and knowledge like commons. And it's just not good enough to say, oh, I've come up with this great secret that I'm going to keep and monopolize, and the world is going to suffer. And it's something I define, totally on my own terms. And so governments have to be much more proactive, and they can be. They're permitted to do so by international law. And the U.S. Defense Production Act allowed the U.S. government to seize trade secrets. I mean, we have provisions in the law. The U.S. government actually issued a ton of what essentially government use licenses on COVID technologies What at the same time they would oppose use of compulsory licenses by other countries. So there's a lot of duplicity as well by rich countries where they act in their own interests. But thanks for emphasizing trade secrets, because we learned so much more about them in the COVID context. But it opens the world for us to see how pervasive they've become and how industry wants to keep secret things that hurt us, and things we need to know.
Yeah, I don't have anything to add beyond what Brooke has said. And on that point, I would just say anecdotally that I was speaking to a person who works in sort of government research funding, and they noted that that recipients of their grants have occasionally, not in maybe huge numbers, but occasionally elected to keep their innovation as a trade secret rather than filing for a patent, in part because of a fear that their innovation would be stolen. And I think the role of government in not allowing that kind of behavior especially when it comes to particular types of technology that needs to be public, like pharmaceutical technology, like climate renewable energy or low carbon technology. It seems like the government agency can play a role there in not allowing that approach for those that are federally funded. That was one side conversation, so I don't know the extent of this, but it's an important idea to know about.
Leah, please ask your question.
Yeah, so thank you so much, both of you. This is with regard to IP provisions in grad union contracts. So I'm from MIT, where we just got what was, to my understanding, a precedent-setting IP provision in that it changed the university policy at all. But it still only addressed the question of researchers getting credit for the research patents, not giving researchers a say in the downstream licensing. And I would expect that the university would actually consider that a really big difference, since right now they get to have the exclusive patent awarding rights. So I guess it's not really obvious to me what the roadmap is, in terms of organizing or in terms of like those kind of incremental steps that you were talking about, Rachel, and getting from the kind of provision MIT got to more direct control for researchers over patent use. So I'm curious about that, like what you would just kind of see as the steps toward getting to that more direct control. And if you think it's possible to maybe jump over some of those steps for future organizing work.
Brooke, do you want to speak to that first?
No, why don't you go first, Rachel?
Okay. I guess, Leah, I think my initial response is, I'm not sure. I've never been through that union contracting process. Skipping steps is rarely very easy, not to say that it's not possible. So it would be interesting to see what it would take for a university to change substantially how they handle ownership, given, as you noted, that sort of the minor concession granted to grad students under the recent contract. So I'm afraid I'm not sure the answer to your question, although I'm very curious. And perhaps if Brooke can speak to that, or maybe even some of the Justices Global folks who are more familiar with these kinds of campaigns.
Well, I think many people are familiar with Universities Allied for Essential Medicine, which was formed, many years ago now, in an effort to convince universities both to focus their research on previously neglected areas of biomedical research, to meet, what was then called neglected diseases, but also to convince technology transfer offices that this absolute transfer of total rights to biopharmaceutical companies was immoral and just politically incorrect, and that they were being hoodwinked about how much power industry had and how necessary it was for them to get total rights. And it's actually a small step to say, well, they want exclusive rights in countries that they never sell to except to a few elites. I mean, the real part of the real outrage here is they want IP rights in developing countries that they don't supply, you know, but they exclude generic competition. And, you know, 87% of the profits the biopharmaceutical industry makes are made on sales in high-income countries. 80% of their dollar volume and a much higher percentage of their profits occurs in rich country markets. And to say that they have to give away global IP rights when they do technology transfer is just poppycock. Industry has really convinced them of something which is demonstrably untrue. And, you know, where you have, you know, basically university research is publicly funded. I mean, NIH should be putting conditions on its research grants to you. You should be putting conditions on your technology transfer agreements with commercial entities. I mean, the idea that there ought to be equitable, affordable access to global public goods is like a no-brainer for any public interest-oriented government or university. And so, you know, I think there's just a battle to, you know, it's a battle to convince your peers, right? It's a battle to overcome the culture that is developed in universities that kind of unquestionably thinks, you know, well, we let someone else commercialize this. Maybe if we're the principal investigator, we actually get rich, you know, which rarely does a postdoc or grad student get rich, I'll tell you that. But, you know, some principal investigators do. But, you know, I just think it's a culture change to say, you know, this is just not good enough. You know, all the hard work you do in collaboration with so many people on the shoulders of so many people before you, and then a private company that's done nothing except, you know, amass some unearned wealth in the past, you know, comes and buys it and excludes other people from having access to it so it can sell at high price to rich people. It's just a terrible, terrible system.
Thank you so much. And on the interest of time, we need to stop the question answer session right now. And Pat and Mark, you can either post your questions in the chat and we'll make sure to get the response. And also we will have a breakout session after this. So we might be able to discuss more of these concerns during our breakout session. And let's thank our speakers one more time. Thank you so much.
Yeah, thanks, Rashmi, and thank you both Brooke and Rachel. I would like to introduce Owen, who will be presenting some slides about Justice's Global's mission and how that relates to the talk that you've all listened to today.
All right, thank you so much, Abhi. Can everyone see my slides? Okay, great. So I'm Owen Letty. I'm a PhD student in biological engineering at MIT, and I'm an organizer with the MIT Graduate Student Union. And I just wanted to speak briefly about why this is a historic moment of strength for organized academic workers, and how we can use that strength to change the unjust IP system that we've just been talking about, and why academic worker unions in particular are a powerful way to do that. So both of our wonderful speakers already sort of went over this, but academic institutions have a sort of unique place within the IP system. They receive grants often from public funding agencies, and because of the Bayh-Dole Act, they're able to retain all of the IP rights to research produced through those grants. So they provide wages to academic workers, and in exchange, all of the IP that the academic workers produce, is assigned to the universities, and they fully own and control that intellectual property in the form of mostly of patents. And they can then grant licenses on that intellectual property to private companies and receive licensing fees and royalties in exchange. And so universities are essentially controlling what happens to the products of our research. So how does this affect us as academic workers? These are just some examples of the types of situations and stories that we've heard from academic workers who are basically upset about the ways in which the IP system impacted our work. So if somebody wants to, for example, wants their work to be widely accessible for global health purposes or for climate technology or some other public spirited use, it can still be patented against their will because of the terms of the intellectual property agreement they sign with the university. Academic workers who want to bring samples or notes with them or other materials to a new academic job may sometimes be prevented from doing so or punished because the university construes this as intellectual property theft. Sometimes grad students or postdocs who want to spin out a company based on their research find that the university has instead taken their intellectual property and licensed it to an unrelated third party, and they no longer have any say over what happens to it. And an ongoing theme that we've heard from many people is just that people don't know that they don't have the rights to their own research and that universities fully control how that research gets used and who owns it. As we've just been talking about, this obviously has implications well beyond its impacts on academic workers and academic institutions. And we've already talked about COVID-19 as an especially stark example of this, but just to reiterate, a lot of publicly funded research went into the development of the mRNA vaccines created by Moderna and BioNTech. But despite receiving all of this public funding, they were able to privately retain the patent rights and trade secrets rights to that intellectual property, and chose to act as monopolists, basically preventing other manufacturers from producing the vaccines, not cooperating with the WHO mRNA tech transfer hubs, and almost exclusively selling their vaccines at high prices to wealthy countries. And this resulted in an extreme disparity in the timing and of the vaccine rollout and the extent of access worldwide, with countries in the global south not receiving access until much later, if at all. And as a result, we saw horrifying incidents like what happened in India in 2021 during the Delta wave of the pandemic, where vaccines already existed. India had the manufacturing capacity to make them, but was prevented from doing so because of these intellectual property restrictions. So obviously we want to change this system in cases where it's getting in the way of innovation rather than helping it or getting in the way of essential public goods. And academic worker unions are a way that we can potentially do that. In 2022, at MIT, we formed our graduate student union, which gives us the power to collectively bargain with MIT, not only over our working conditions, but also over who owns the work we produce and how it gets used. And this is part of a much broader trend. In 2016, Columbia University sort of kicked off a wave of unionization efforts at private universities after the NLRB ruled that Columbia graduate student workers were allowed to unionize. And more recently, our unionization vote in 2022 came at the beginning of a renewed wave of grad student workers voting to unionize, often by really outstanding margins of over 90% in some cases. So this is a really landmark moment of strength for academic worker unions. This is also manifested in some strikes that have happened recently, for example, at Rutgers University and at the University of California system, where academic workers won really significant institutional reforms as well as better wages and working conditions. Not only is this wave of labor organizing a reason to sort of have confidence in our strength and our power as organized workers, but also as a result of, as a sort of delayed effect of the passage of the Bayh-Dole Act that we talked about previously, academic workers are increasingly central to the production process in high-tech industries. So because I'm in the life sciences, I'm going to use a couple examples from the pharmaceutical industry, but the same could be said of other industries too. Over the period from 2000 to 2015, the percentage of the top-selling pharmaceuticals that came from IP produced at academic institutions increased from less than 20% to over half. And over a similar period, the number of companies spun out from universities using IP produced at those universities also dramatically increased. And so increasingly, IP that's essential for pharmaceutical companies, instead of being produced through in-house research, comes from either directly licensing IP from universities or acquiring spin-out companies. So this puts us at the center of the production process for these industries, and as a result, as organized workers, we have the power to change those industries. We already talked about this briefly, but MIT GSU recently settled its first contract, and we're, as far as we know, the first graduate student union to actually win any kind of change to our university's IP policy. The changes that we won are fairly modest, but they do, for example, guarantee graduate student workers the same IP rights as principal investigators, and create an official process for adjudicating disputed IP claims, which previously were resolved only through informal channels. And so this shows that this sets a precedent that universities not only have to negotiate with us over wages and working conditions, but also over ownership of the work that we produce. And we can potentially build on this precedent to more fundamentally change the IP system at the universities where we work. So after talking about these issues with academic workers at multiple institutions, these are some of the ideas that we've come up with that we think we can potentially put into future contract proposals for union contract negotiations. The first is just more transparency around IP policies so that people actually receive training and instruction on these issues and really understand what they're agreeing to when they sign on to their university's IP policy. The freedom for academic workers to share knowledge and materials, as long as it's uncompensated and not for commercial use. We think people should be able to share their work with their collaborators without fear of any kind of censure from their institution. If researchers believe that their research can have the greatest impact by being released under an open source license or otherwise made freely available, we should have the right to do that, even if the university retains the right to share in any commercial use. Academic workers should be fairly credited for their work and receive fair attribution, especially given how important that is for our careers. And researchers who are moving on to another institution or another stage of their career should be given a fair chance to license back their own inventions or patents from the university rather than being excluded by a deal with a third party. And finally, when the university is negotiating with commercial partners or otherwise seeking to commercialize a given patent, researchers should have a seat at the table in determining whether a given licensing agreement is in the public interest, and have a voice in determining the terms under which our technology can be licensed. And there are a lot of potential benefits from this, both for us and for the world. There would be fewer barriers to collaboration, exchange, and innovation. Licensure of technology would occur under more ethically responsible and less exclusionary terms. There would be more equitable access to the benefits of science and technology and fewer barriers artificially placed in the way of global economic development. And it would protect the careers and material interests of us as academic workers. So if you feel moved by what you've heard today and you want to help make this a reality, if you are a researcher, especially if you're a member of a union, please organize a training or information session on the IP system and how it affects academic workers with your coworkers, your fellow organizers, and your colleagues. We'll be sending out information that will include these slides, and we are happy to provide materials and assistance if you want to make sure your union or your coworkers are informed about this issue. If your union has elected officers or bargaining committee representatives who are going to be going into negotiations, please make sure that they know that intellectual property is an issue that matters to you. You are their constituents, and if you make this an issue that they need to pay attention to, we're more likely to see more of these provisions appear in union contract proposals. And lastly, it's important to just be informed. So read your university's IP policy. They do vary somewhat among institutions, and think about what proposals you would put in place to change it, to give you more of a say in what happens to your research. And if you're not a research worker or tech worker and or you're not in a union, there's still plenty of ways to push for greater access to climate technology and essential technology for global health. And we'll be sending out a sign up. I think I saw Ben just posted it in the chat, where you can sign up to receive more updates from Justices Global on ways to support these campaigns and push for a more equitable distribution of science and technology. And I will wrap it up there and pass it back to Abhi. Thank you so much for your attention.
Great, thank you, Owen, for that presentation. And now we'll be going on to a small group discussion in breakout rooms. And I think Ben will be organizing that.
Yeah, we lost some folks because that's how it happens with these calls, and I think we have enough people. Maybe we can have a small group discussion here, and we had a few questions to ask. And just because if we break up into small groups, we'll have very small groups. So, so I wanted to just ask a question. We had a few questions in mind, but maybe the question that's most on my mind is like, how does the stuff we talked about that Brooke and Rachel and Jeremy and Owen talked about relate to stuff in your own work? And if not, we can get into Leah's question about what's the roadmap, like a little bit of some questions about strategy, like what we can do from here, kind of drawing on Owen's presentation. So I want to just ask the question, like, what resonated with you? What showed up in your own work? Are there ways that you saw connections or made new connections through hearing from our speakers today?
Yeah, so I can start. I am a union organizer. I organize with postdocs at Weill Cornell Medical School. We're building towards having an election probably in the next month or so.